Sometimes we are confronted with the issue of whether the artist has the right to make changes in their work after it is completed. And what does completed mean exactly? The standard opinion has always been, once the work is completed, it becomes a relevant document of its time, which means that it should be protected from any future alterations by the artist and by the conservator. Lawyers and the practice of art law can provide a common ground, or at least some standards that help us navigate our decisions within the complex field of obligation and rights of those involved. This is one of the reasons why we invited our following guest. John Cahill and his New York-based law firm, Cahill Partners LLP, focus, amongst other things, on intellectual property and art law. They represent all parties involved in the art market, such as artists, collectors, art dealers, and so on. John publishes and lectures frequently on various art-related matters. And we are very happy to have him here today to speak about the rights and obligations of both the artist and the collector. Please join me welcoming John Cahill.
So good afternoon. I'm taking you into your coffee break, so if you can just stay awake for another 25 minutes or so, we should be good. So I'm here to talk to you about the law, although very interestingly, you'll see that the title of the talk concerns moral rights. So, in my practice, people are often calling me up and asking me questions to which they think there is a definitive answer. What is the law? And very often there is, but very often there isn't. Occasionally, people ask me, well, what's the law and what's the morally correct thing to do? And those are my favorite kinds of clients because I just get to tell them what to do and what I think is right, and hopefully it all works out. But that's rare. And this, the law of what happens with art is one of the most fascinating areas of the law for the simple reason that if you think of engineering as applied science, law is really applied philosophy, applied public policy, and applied morality. So I'm going to talk to you today about the law. I may say some provocative things. Sometimes there really is a law we can look to. It's like the gospel. It's the Bible, you can say to it. But sometimes it simply raises questions for which the answers are decided by other people. And that's particularly true in the area of art, and it's particularly true in the area of moral rights because these things are really hard to ascertain. So let's see if I can make this move. I'm not sure I can. Maybe Mr. AV person can help me. Well, maybe I'll just do a quick poll here before I broke it already. So maybe I'll just do a quick poll here. So in terms of public.
Yeah, black it out real quick.
What's that?
That's fine.
Okay. So in terms of what the public policy is. Oh, sorry. In terms of what the public policy is, in terms of and what the law is. At some point along the way, and it was thousands of years before there was any law having anything to do with artwork, in ancient times, in Roman times, you could paint a sculpture, and many people did. But it wasn't really until after the French Revolution that the idea of moral rights came up. And we could have, as a society, and different societies and cultures have done different things, and decided what could be done with artwork. On one extreme is what we had in this country really well into the 20th century, which is if you own a work of art, you can do pretty much whatever you want with it. And the other, I'm not sure if it's extreme, but the other end of this spectrum really happens in Europe, and particularly in France, where there's a droit moral, which is the artist has such rights that if the artist chooses, or his or her heirs choose, they can destroy a work of art that is not distributed to them. So the question is, for those, you all know better than I, that this is not really a damaged work of art. There may be some lawyers in the room who don't know this is an actual intentional work by Fontana. Some of you may recognize this work too. When my children were younger, they called him the Champ, a work of Duchamp. But imagine, if you would, for a question, is if Leonardo was alive today, could someone do this to his work? Or if this was say, an early experiment by Ed Reinhardt in yellow, could someone do this to his work? That's what we're here to talk about in terms of what the law is. And the answer, by the way, is with respect to both is probably yes today. In the United States, they could probably both prevent this from happening, maybe less so. So I just see there are a couple people, most people are from here in the U.S., but I just want to be clear that we're talking about the law of the United States today, not the law of that's present. Other countries have different laws that relate to moral rights, and they differ significantly from U.S. law. And one of the most interesting philosophical questions and legal questions lawyers have to confront is what law applies. And the answer to that is very often it depends, and people can argue about that. But today I'm going to be talking about the law of the U.S. And again, for those of you who are from out of town or out of the country, that means it's the law of the federal government here, the United States government, which is run by the Supreme Court, not necessarily the state laws. What we have here is a federal statute that was not written by Renee Vera, although it's commonly referred to as VARA. That's why she got picked to speak. She actually doesn't know anything about insurance or any of that stuff. But it arose here in the U.S. because this work, Tilted Arc, which you don't see downtown in New York anymore, caused a lot of controversy, and it was moved, and it really spurred a discussion in society and in Congress about what we should do here in the U.S. about moral rights. A lot of people love this work. A lot of people love the work of Richard Serra. A lot of the folks who lived and worked down in that area decided it was an abomination and they wanted it out, and they succeeded. And that made a lot of people irate, justifiably, and they asked Congress to do something about it and to establish a regime of moral rights here in the United States. And Congress obliged, but only to a degree and to a lesser degree than was done in Europe. And what they passed was something called the Visual Artists' Rights Act, and it's part of the copyright law. It's in the same section as the copyright law, which is Section 106 of the United States Code. So remember, this is a federal law. And the name is very telling. It's the Visual Artists' Rights Act. So it's an act that gives rights to artists. One of the things you'll see in your brochure is we talked about what are the rights of artists, and this addresses it, and what are the obligations of collectors and others who own art, and that's essentially to observe the rights of artists in some way. But this is about visual art, so it doesn't necessarily apply to things like other things that are copyrightable, like sound recordings or even video necessarily. There aren't a lot of cases in that, but it's about paintings and drawings and sculpture, and it's about visual art, and it's about those things in very limited quantities. So it's not about necessarily things that are mass-produced on the web or things like that. So it's a fairly narrowly defined definition of what visual art is. More narrowly defined, I would say to you, than anything that folks in the contemporary art world would say actually is art. It may well be too narrow. But that is what the law protects. And what it basically says is it's, as you can see, it's a few pages long, but what it basically says is an artist can forbid the use of damage or modification to an artwork or using his name or her name as the artist once it's been damaged after the fact. And it also says that an artist can prevent intentional damage or modification of an artwork before it's damaged. So it gives an artist rights after something happens, and it gives an artist right before something happens. And it doesn't apply to all works, however. This was a law that was discussed and passed in 1990 and went into effect in 1991. So it really applies to works that were created mostly after 1991. There is a little exception that if the artist had the work prior to 1991 and she did not pass title to it, the artist still has rights under the Visual Artists' Rights Act up until that time. So there was a lot of debate in Congress about this. A lot of people, particularly in the art world, wanted to have give artists more rights than they had or equivalent to those in Europe. The issue with Richard Serra's sculpture was that it was moved. That work was not destroyed. but that work and other works are often created for a certain space, and the artists feel that that site-specific spot is exactly the space it should be in and should not be moved at all. That didn't make it into the law. So there was and is no protection for artwork that is at a specific site. So I was asked to specifically to say about what collectors can do. Some of you are collectors, some of you conservators, what they can't. But again, I'm trying to give you a simple summary. I'm going to try and get into some cases later so we can talk about some of the nuances. But at its most basic level, the law says that you can't wrongfully attribute a work to an artist. What does that mean? If Christian Wool didn't paint it, I can't say that's a wool. Please give me $20 million. That is specifically prohibited, damaged or not. A collector can't seriously damage or modify an artwork. And when I'm using collector as a stand-in for owners or other people, it could be museums, it could be other people. The word seriously is not in the statute, but that is the essence of what the statute says. And of course, an owner can't destroy an artwork of recognized stature, and we'll talk about that as well. What is a work of recognized stature? There's a big case going on, right across the river in Queens about what a work is of recognized stature. It doesn't say that here you'll note that a collector can't conserve a work or do anything to a work, or that works can't decay. It says these are things that collectors cannot do. What can artists not do? Artists can't disown a work. And again, this is about, VARA is about the integrity of an artwork, its physical properties, and its attribution. So an artist is entitled to say, that's not my work, but an artist isn't necessarily entitled to say, and give it back to me, please, so that I can destroy it. You heard Vera say that that's very often the case. That's what she prefers and she thinks should happen. I happen to agree with that in most cases, but there's nothing in the law that says that has to happen. So what the artist can say is that it's not my work, but in theory it can be exhibited or shown and continue to be held by someone. But the artist can't do that. It's just because there are changes to the weather or changes to an art because of weather, patina. If as we saw, the materials disintegrate, that can't. That isn't necessarily something the artist can use to call attribution. For those of you who are conservators in the room, there are a lot of you here, I see, the artist can't refuse to attribute a work because the conservator was negligent, not just plain old negligent. You could do a pretty bad job, and as long as you weren't grossly negligent, the artist isn't entitled to do anything. So I know there are no mediocre conservators out there, but if you are mediocre, the law protects you. You just have to be grossly negligent. The other thing is that artists can waive their VARA rights, their moral rights in writing. And how often do people think this happens? Just a quick show of hands. I'm not going to name you. It happens a lot. It happens a lot. And who do you think are some of the biggest people to ask? Are sometimes museums are asking artists. Real estate developers who commission artwork, it won't shock anyone. They always ask, please, sign here, waive your rights. But museums not infrequently, and collectors not infrequently do ask for some waiver of VARA rights. And if we have time, I'll talk about how that sometimes plays out. So collectors obviously can do conservation on artwork. That should be a relief to those who are conservators. The conservators are allowed to do the work. The collectors can hire people to do that. No one says that they have to consult the artist. As you heard from Vernay and you've heard from some other conservators today, that's not a bad idea. Sometimes it's a necessary idea. Sometimes people think it's very, very important, but it's not a legal requirement. People can let things weather. They can let things change, and that doesn't mean it ceases to be the work of the artist. And the other thing that collectors can do theoretically is they can get an artist's permission to change something. I never really liked the Mona Lisa without a mustache. Would you mind terribly if I painted it? Eve Glenn, your blue is just a little too bright. Could we tone it down a little bit? Theoretically, they can do that. If the artist gives you permission, you can do whatever you like to do. But I wanted to give you, and again, I don't know if these PowerPoints are available, but I can happily send anyone the law, but I wanted to give you some of the words that are in the actual statute, in the law, about how bad the damage has to be, so that you would see that they're pretty strong words. They're the equivalent of fighting words. There has to be distortion in some cases, mutilation, or at a minimum, a modification that's prejudicial to an artist's honor or reputation. And here's where you can get into a lot of arguments about what that means. What is prejudicial to an artist's honor or reputation? What's distortion and mutilation? Has to be, pretty bad, I think most people would say. But it doesn't say things like, it's a little bit of damage, or damage that the artist subjectively feels changed the character of the work. It's the amount of damage that Congress provided for in the law is a really fairly serious amount of damage, which is very often surprising to people in the art world, because we all have a lot of respect for artists. And this doesn't say that we shouldn't have that respect, but it establishes a pretty high bar for artists in terms of what they can do in preventing or declining to attribute their work, which also raises a lot of questions. So again, assuming this was a living artist today, distortion, mutilation, I would say for sure. But interesting question having nothing to do with the law. If the artist was alive today and said, forget it, I want that thing done, I want Rene Vera to bring it back to me so I can destroy it, would that be a good thing? Would that be a good thing for the culture? Would it be a good thing to society? Should the artist be the one to decide that? Could an artist be wrong about when their work should be destroyed? Or, as one of my partners often tells me, the artist can never be wrong because it's the artist's artwork. And so the artist should ultimately get to decide. Under the law, that is not the case, but certainly with respect to what distortion, mutilation, I think this would qualify. Renee mentioned this work. This is, I think, an image of the work, Le Rêve, that was at the Aquabella Gallery after it was sold, or maybe when it was being sold. It went well into the 9 figures. Renee, do you know how much it was? Was it 150, 130? It was originally sold. This was the one where it was about to be sold. The elbow went through. Insurance claim was made. Rumor has it an insurance claim was paid for a large sum of money. It then went back on the block. It was purchased. Again, a pretty substantial hole, a noticeable hole, a real distortion. Maybe some would say a mutilation. Again, this is an older work. Picasso wasn't around at the time. But food for thought, if he was, and if it was covered by Vera, could have and should have we allowed Picasso to say, I want that back, I want to burn it, I want to have a bonfire on the word. And it's interesting in this particular case, because it's not just that the work was was conserved and well conserved. I mean, if you can see, I looked at it, and I've talked to people smarter than me and who have better eyes than I do. Boy, it's a heck of a conservation job. I mean, it's really phenomenal. It had to be pointed out. It's somewhere in the forearm, but it was phenomenally well done. And the question is whether putting a hole in a work of art in a canvas, which happened here, is sufficient under Vera. I don't know. I'd be interested to hear if any folks think that that should happen or shouldn't happen. But I think there's certainly artists in the world, and people have made claims like that, and certainly collectors do as well, and might say it's a total loss. But is it a total loss? I mean, that's where the law is not 100% clear. I would say, if you're looking for just my personal opinion, it wasn't a total loss, and clearly this is a phenomenal work of art that not only everyone can value as a cultural object and as an aesthetic object, but again, even after the repair, people paid well in excess of $100 million for it. But it's interesting to contemplate what would have happened if it was covered by Vera, and whether somebody could have done it. So there are lots of technical details in the statute, as there always are. As I mentioned, it only covers really visual art. It doesn't cover things in large editions. It's a 1991. It also doesn't cover works for hire, which sometimes happens. It happens with artists. It happens with studio assistants. There hasn't been a case where an artist who creates his or her works by studio assistants has ever had to deal with this issue. And it's also it's the right of the artist. They were clear about this because although it usually doesn't happen, I can count on the fingers of one hand how many times an artwork has been sold with the copyright. When it happens, it's usually a photographer that does it, and it's usually someone willing to pay a lot for it. But usually the copyright does not transfer. The right to reproduce the artwork doesn't transfer with the art, but in theory that could happen. But even if that happened, the statute says, look, we're here talking about the artist, and if there's more than one artist, as there sometimes is, then both artists have the right to do it, although only one can waive it. The artist also has to present, the artist cannot prevent the destruction of a work of art that is not a recognized stature. And those are literally the words in the statute. But it's not clear what a work of recognized stature is. I'll talk about that in a minute. I'm running out of time a little bit here, but the last point here is what I wanted to emphasize, again, is that artwork that deteriorates naturally is not subject to VARA protection. So, a lot of times things that are outside or things that are made of organic materials are not necessarily covered by VARA protection, which is surprising. It doesn't mean they're not worthy and deserving of conservation or the artist shouldn't be consulted, but they're not necessarily covered by the Visual Artists' Rights Act. So what if you are buying or selling a work of art, or you're an advisor, or you're a conservator working with someone who is buying a particularly contemporary work of art, and the issue of the Visual Artists' Rights Act comes up? And the best advice I can give you is that you should do it in writing, and that's not just because naturally lawyers make money when you put things in writing. It's because the statute actually requires it. If you want an artist to waive her rights under VARA, it has to be in writing. If you're an artist and you want to increase your rights beyond what's in VARA, it has to be in writing. But as many of you know who are out there in the art world, so many things are done on a handshake or on a single piece of paper that things are very, very, very often not done in writing. So, for example, shockingly, maybe many of you heard about what happened at Mass MoCA. It's a while back now. No contract. No contract. This was an enormous installation. I believe more than 7 figures were sent. Major contemporary art institution. Airplane fuselages. You can see things going into gigantic building. Nothing on paper. Some emails, some little bits of paper here and there, but nothing on paper. And what basically happened is the museums, wherever you come out on this, the museum at least said that it was really running out of time, running out of money, needed to get this thing done and wanted to get it opened. And the artist said, I'm not ready and it's not my work. And the museum said, we're going to display it in some form. Anyway, a big lawsuit ensued, and the artist was able to keep the museum from doing some things, and eventually it was resolved. But the museum's position was it's not covered by VARA because it's an unfinished work. So this is really important and something that most people don't consider when they're buying or selling or acquiring or commissioning works of art, is putting things in writing. And it's really important because it makes you think about what you want to have done. So things that you can put in a contract that can go beyond what your moral rights are, depending, either here or in the U.S., are things that collectors can do. They can request waivers, including the ability to destroy artworks, to move them, to fix them, change them, to paint them. None of these things are things that I particularly think are good ideas, but there are things that people who buy artwork, including very wealthy people, sometimes ask to do. It's very common among people who are commissioning artworks for private public display. So someone building a big office complex, they're thinking real estate. They're thinking, I want to be able to do this. Of course I should be able to do this. I'm paying for it. What if I want to put in a Starbucks where this sculpture is going to go? The good news is that the law was created precisely to prevent that. But if you're an artist and it's a particular commission, you want to do the commission. I represent a lot of artists to do this, and I say, look, it's kind of shocking, but And typically, these things can be resolved in one way or another, and the way they're often resolved, and the statute provides for this, is that the artist might say, look, if you're going to do something, you have to notify me. You have to notify me or my heirs or some designated person, and I have the right, I, the artist, have the right to come do something, ideally for free. And there are some things you can't do. You can't just destroy it. But often that's, believe it or not, a sort of a negotiation and a leverage. So it's a question of who's got the power and who's got the money, and often that's the person who's buying the art, and often it's a museum who's making these very same requests. Artists may say, I don't want this move, it has to be here. Imagine a Turrell light sculpture. You can't say, I want to move that so it's, underneath a tunnel, but a museum might have that kind of language in a contract. Similarly, the artist can make demands. The artist can make demands of the buyer that go beyond VARA. I don't want you to touch it at all. I don't want you never can do it. You can't even think about changing it without contacting me. So I'll just run through. So the concept that some artists have, Goldsworthy being the most prominent example, that he's okay with things deteriorating. He wants them to, and I think he is actually, rumor has it, said to people, if it's deteriorating, you can't fix it. You can't conserve it, and he can do that. There's a case actually about a grossly negligent conservator. I just want to show you the picture of what recognized stature is often determined by experts. People call in experts, but the issue is often very tough to determine. Is this a work of recognized stature? Is this an artwork? It's done with flowers. 5 points is what's going on now, and that was whitewashed over. There wasn't time to do anything about it, depending on your point of view. Again, real estate folks saying, it's my building, I'll do what I want. The judge felt he really couldn't do anything. And I'll just leave you with this last case, because I think it raises the most interesting questions recently that were never resolved, which is a work by Katie Noland, who some of you have heard of. This work, according to her, was very seriously damaged and unsellable and deemed not her work, according to press accounts and lawsuits that were filed. And according to other people, was people whom you all respect, there certainly was something that happened to it, but it wasn't destroyed, it wasn't mutilated, it wasn't distorted, it didn't cause any prejudice to her reputation, and yet it was withdrawn from sale by Sotheby's. And the interesting legal question that was really never resolved, and that I put to you as an interesting question you should think about, is should Katie Noland have been able to do that? Should an artist be able to do that? And what should happen if the artist does, and he's wrong? Should the artist have to pay money? Somebody lost a lot of money. I can't remember what the estimates are here. It was well over $1 million. And the issue wasn't decided, as I have a little summary here. What they wound up doing was suing Sotheby's. And Sotheby's, I was an auction house general counsel. I still represent Sotheby's, so take everything I say about auction houses with a grain of salt. But just like insurance companies and people who get sued a lot, they develop their contract to say, hey, if someone makes a claim, we don't want to be in the middle of it, and we can withdraw work without any consequence to us. And that's what happened in the lawsuit. And the issue of whether Katie Noland did the right thing or the wrong thing was really never decided. So with that, I'll wind up and I'll answer any questions you have.
When you talk about a contract and there being language, one thing that's happening more often is invoices get issued, and on those invoices are kind of conditions of sale. And they might include first right of refusal language or language around rights of the artist, separate from standard copyright rights. Sometimes they're discussed at the time of acquisition. Sometimes they just kind of sneak in there. Either way, it's not an actual agreement. So my question is, if in the instance a client pays that and accepts that invoice, is it a binding agreement to those conditions?
Okay, so the answer to that is the usual answer of all scared lawyers, which is it depends. But it's also really true. It really does depend. Very often for the things like rights of first refusal, those galleries do get it signed. But the question is if it's not signed. Then you have what lawyers and judges and courts call issues of fact that get determined by people who are deciding and often hearing testimony. So paying, for instance, if you get the invoice and you pay after they can show you see the invoice, some people would say, yes, you've accepted it. We formed a contract. Some contracts don't have to be in writing, although ones for more than $500 in New York do. But you can take it out of that requirement that it be in writing by performing it. So I gave you an invoice, you paid, you accepted it, so I say we have a contract. But there's also another legitimate argument, well, not really, because we discussed something else, and maybe there's an email that clarifies it in some way. But it's certainly a risk to just get an invoice and pay it, and it's a big risk in the United States in general because we're a litigation-happy culture, but you do run some risk if you get an invoice. Conversely, not getting all those details in an invoice is also a risk because you don't have understanding about some things. For example, what the artist's rights may be, and that may be important to figure out before you buy, as particularly contemporary work with a living artist. It's good to know.
Hi, James Ham. Before VARA, there were 10 states that had instituted their own artist laws, protection for artist rights, primarily California and New York. But is it true that VARA supersedes those laws, or I've read that some of the more generous portions of the state laws are allowed to stand?
Yeah, I think
that?
Yeah. So I think again with the caveat that lawyers like to think carefully and do their research before they answer questions. I think that my best guess and my reasonable belief, and I think it comes from the case involving the dear departed David Wojnarowicz, tried to make a claim. I think the federal law generally preempts the state law, and so you're generally stuck with whatever the federal law is, even if the state law is more preempted. And I believe in the Wojnarowicz case, it was right on the cusp, and the court applied the federal law. But I offer that with the caveat that I haven't looked at that in a while and don't have an encyclopedic knowledge of it. But the federal law is the one you really should be looking to, and it generally preempts the state law. When the federal government steps in, much to the dismay of certain people who are all about states' rights, generally they occupy the field. We'll see if that's true when the Supreme Court decides the gay marriage case this June.
I have a very quick question. Are there any legal requirements that the life of the artwork somehow follows the artwork, that the history of, let's say, claim settlements and all that belongs to the work of art, 50 years from now, that somebody can look it up, what happens to it? Or is it seems it's so not regulated, some people keep very good track of it, and some documents just don't exist, so are there any legal requirements?
There aren't really many, which is why it's good, Renee's suggestion that the artist get the work back, and I try and do that when I'm, if it's something really totally damaged, I try and do that so you sort of take it off the market. But even with fake works, there's no obligation that, sometimes they write it on the back, it's a fake, but that doesn't happen. The exception to that is people, again, if you have a contract, ideally it would say, you've told me everything you know about it, and I often ask when I'm representing someone who's buying an artwork to tell me what the conservation history is. So you could talk to the conservator, and I always recommend that people, for those of you conservators, that they go to a conservator before they buy an artwork. But the answer is there's no real legal obligation, and your concern would be you might buy something that was so damaged that it really no longer is the work of an artist legitimately under VARA. There's not really necessarily a legal requirement, except if it essentially becomes a fake. And if you find out about it, that it's not the work of the artist, you have about 4 years to sue subject to fraud and ask for it back. So in that sense, it's a legal requirement. If it was so badly damaged, you could, but not a lot specifically.
I just wanted to add that when a work is transacted, it at least in the States, often, as consignment agreements, contracts with auction houses, all of them have a disclosure clause, and it suggests that you have to disclose anything. And certainly if you're asked a question, you are obligated. So in that way, it is kind of regulated because it's a common occurrence amongst any people who are carrying out transactions that is part of the condition of sale.
Yeah. Yeah, you can, in that sense, you can take a lesson from the auction houses. They ask people to say, has there been conservation? Do you know anything about it? They have conservators look at it. But very often, I will tell you, very often, I always suggest my clients get an appraiser, get a conservator. They will say, the dealer showed me under a black light and it looks fine. But obviously, that's not enough.
I just was actually interested. Well, thank you so much. It was so insightful, and I learned so much from your talk. I'm actually interested whether there is some kind of law, yes, Hannah Hölling, Bard Graduate Center, whether there is some kind of law that protects actually the work of a conservator. We are talking quite a lot about artists, but in a way, conservators take an important role in the creation of the identity of many of those works, especially contemporary art, you know, installation or, yeah, technology-based art. So I wonder whether you could speak a little bit to this point. Thank you.
Yeah, yes, I think there is in VARA, it would be hard for an artist to sue in VARA, or even because of the grossly negligent requirement. And there are some people who are doing conservation who shouldn't be, but there's a high standard there. But those protections are usually best established by an agreement between the person you're doing the conservation for and you as the conservator. And it's usually a contract, and sometimes this is written down. It's good when it is, and those things should say, I'm not responsible. You know, this is for anything that isn't grossly negligent. If you're the conservator, insurance companies often don't cover work that's being conserved. In some instances, I shouldn't say often. In some instances, because there's, as you know, when you're doing your work, but there's no absolute protection even for gross negligence. So that if you do something that's so terrible, if you decide to make it look like Alicia Fontana, you could certainly be found liable. But for the most part, there is some protection under law, but it's best established by agreement. And of course, if you happen, and I won't say who, but even conservators have accidents. They have something up on an easel, and it falls down and it gets damaged. Then I hope you have insurance for that, because that's something you can be sued for. But the standard of what your protection is the standard of your fellow conservators, and you're only responsible for the things that is outside of what a reasonable conservator would do. But that's hard. But the best way to do it is by contracting to get people to agree what you're responsible for.
Okay, two last comments, Joanna and then Reinhard.
Yeah, Joanna Phillips. I work with time-based media works, performative works, installation works that are unstable by nature and require a certain degree of interpretation every time they're installed. And I wonder if you've ever encountered the case where an artist has made use of his right to prevent unwanted change when it came to an unsuccessful representation of his artwork, a poorly interpreted iteration of his artwork.
I have seen that, although not under the Visual Rights Arts Act in the sense that it was damaged or something like that. It usually arises in a copyright claim. You don't have the right to use my artwork in that because it's poorly interpreted. We saw that with Richard Prince in the Carry You case, where Richard Prince used some photographs. The artist photographer made a claim, but I haven't seen it in the context of a moral right, I have to admit. But it doesn't mean it couldn't be made. I can't think of it off the top of my head. But in the copyright action, it's fodder for legal issues because of the right of the artist to say, it's mine, you can't use it at all, even a little bit, which is what happened in the Prince case.
I wonder if the Nocera work downtown could have been saved by landmarking it.
Interestingly, yes, it could have been, and maybe should have been, but there's a process that goes through that. But that is something that is available for artwork, and I think they did that in a building in Philadelphia once with respect to a mosaic. But interestingly, which is one of these things that's why these decisions, when I'm often talking to a real estate developer's lawyer, when they literally say, well, why shouldn't I be able to destroy it? I'm just going to pay you $2 million for it. I say, well, maybe maybe you're not the right person to decide, or maybe the person who buys your building isn't the right person to decide. Maybe you should go visit Penn Station and you should see what people do sometimes, and sometimes they may be right. But that would have been an interesting idea. It was hugely publicly unpopular, but I think today, maybe I'm wrong, just being at the DIA, I think today some of those same people might be sorry that it's not there. But that would be an interesting idea, but it's never been tried. It's a good idea though for public artwork, especially that's not protected by VARA. Okay, sorry about that. Thank you.